5, and we're going to talk about Sean Combs. And let me get to YouTube chat. Okay, what happened? Did we trigger somebody's fifis? Scooter, are there people that got triggered? They got hit in their fifis? Their fifis are in a kerfuffle? What is it? Kerchuffle? Their fifis are all up in a bunch? Flattered you keep making profiles. Your fifis must really be hurting. What's up? You gotta keep making new profiles. You're really following everything we say, huh? Pathetic. You look pathetic. You don't even realize that. Okay, let's go. We're going to talk about Diddy first. Hi, Gail. Hi, to Scooter. Hi, little lady. Hi, Jeanette. Hi, everybody. Hi, White Angel. Get in top chat. That's where to be. Top chat. And hit the thumbs up. And, yeah, kerfuffle. I can't even speak tonight. Okay, so let me get to, let's look at what happened with Diddy. 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 All right. Okay, here's Deontay Nash. Right there. So Sean Diddy Combs, P. Diddy, Puff Daddy, Diddy Do It, once beat his ex-girlfriend Cassie Ventura so badly she needed stitches on her forehead. This came from Deontay Nash, who was a stylist for both Combs and Cassie Ventura. And he testified, told the jurors that there were times when he witnessed Sean attacking Cassie and others. He testified that he saw Sean Combs threaten to release sex tapes of Cassie Ventura in drug-fueled freak-offs with male prostitutes. Testimony came as it emerged. Cassie had given birth to her third child, a son, with her husband. Of course, Mr. Combs, 55, pled not guilty of racketeering, sex trafficking, and transportation and to engage in prostitution. But Mr. Nash was one of 3 witnesses to take the stand. And he said several times he did not want to be in court and that he was summoned through a subpoena. Mr. Nash said he saw Cassie almost every day while working as her stylist, and he became a close friend of hers. He told the jury that he witnessed Sean Combs abusing Cassie on several occasions and asked what names that Sean would call Cassie. Nash said he would refer to her as an SLUT and a hoe, among other derogatory terms. He told the jurors that Cassie Ventura had confided in him that she did not want to participate in those freak-offs. In one incident, he testified that Sean Combs showed up at Ventura's Los Angeles apartment while she was asleep on the sofa, that he shouted at her and grabbed her by the hair and started beating her. He testified that he and Cassie and an assistant to Sean Combs that was named in court only as Mia tried to run into a bedroom and close the door, but Sean Combs managed to get in. He continued beating Cassie until she hit her head on a bed frame and started to bleed profusely. Nash said he and Mia tried to stop Combs by jumping on his back. He said they also tried to call emergency services, but Combs told him a member of his security would take Cassie to a plastic surgeon. And he said that he saw her on a video call the next day with stitches in her eyebrow. He started as an intern for Combs on the record label Bad Boy. He said he became a stylist when he met Cassie Ventura in 2008, and he still remains close friends with her. Defense attorney asked him about the last time that they spoke, and he said yesterday after she had the baby. He also insisted the defense lawyer referred to Ms. Ventura as Mrs. Fine, since she was married to the personal trainer Alex Fine in 2019. Mr. Nash said he also advised what outfit she should wear while testifying. The jury also heard testimony from Los Angeles Police Department officer and a Los Angeles Fire Department official. They testified about conflicts between Combs and rapper Kid Cudi, who took the stand last week. Arson investigator Lance Jimenez told the court about being called to examine Mr. Mescuti's Porsche that had been set on fire in his driveway. The court saw more photos of the burnt Porsche and a bottle of petrol that fire and arson investigators said was a makeshift Molotov cocktail that was used to set the car on fire. Investigator also said fingerprints were recovered from the crime scene, some that had been a partial match to a woman whose identity is unknown. Arson investigators said that other prints in an envelope, they were sent in an envelope and sent them to LAPD, but they were destroyed without his permission the same year. Isn't that interesting? Prosecutor asked him if that was unusual, which led to an objection from Sean Combs' attorneys, who argued that prosecutors were trying to claim that someone in the room was responsible for the destruction of evidence. Defense attorney Agnifilio asked the judge to declare a mistrial based on what he called was outrageous questioning. The request denied, but the jury was instructed to disregard the testimony. Mr. Nash is scheduled to return to the stand on Thursday, followed by a former personal assistant to Mr. Combs named Mia. Her testimony is expected to take up most of the next 2 days of the trial. That should be interesting, right? That they said they were supposed to get to these 3 today, so they're a little bit behind schedule on that. And let me see here. Karen Reed's defense team, of course, ripped into the reconstructionalist, the crash reconstructionalist testimony, which, was going to be the thing, right? Let me get this here. That's Alessi. Where the heck am I? So the defense tears into the crash analysis, targeting gaps in the state's theory of collision. Thursday is going to be a half a day. So they have a very short week, right? Because they already had nothing on Monday, and The judge called court into session Wednesday morning, and they were set to continue with crash expert Dr. Judson Welcher's continued testimony. Before the jurors entered, the judge issued a ruling allowing Welcher to testify that this investigation found the damage to Reed's Lexus SUV to be consistent with a collision on January 29th of 2022. Cannone also decided that Welcher can testify that John O'Keefe's injuries are consistent with being struck by a Lexus that is physically identical to Miss Reed's Lexus. The opinion is based upon other things, his experimental work that came into evidence without objection as to scientific methodology and application, the judge said. She then sided with the defense by ruling Welcher cannot testify that Karen Reed's vehicle specifically collided with O'Keefe. Okay, the jurors are as well positioned to draw or reject the inference as is the expert. The judge said that is, the inference is not compelled by the application of any scientific method. Prosecution is expected to rest its case this week, setting the stage for Reed's team to begin laying the groundwork for their defense. Her defense team will continue questioning the state expert on Thursday, which will be a half a day. Defense attorney Robert Alessi attempted to poke holes at the state expert, Dr. Judson Welcher's reconstruction of the crash on Wednesday, saying, "But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit the spoiler. You don't have that information, correct?" He said, "We don't have that level of certainty. We have the height and the geometry matches." And then, again, I told you that he was being paid $325,000 to do this analysis. Shannon Burgess, that was another expense. But that's what experts in these legal cases get. They get an astronomical sum of money to align evidence the way they want it, right? Let's see, so they'll be on that tomorrow, but okay, now let me get back to the chat here. So all right, next up, let me take a look at what is going on. Okay. So there's that jet ski thing. See what else. Okay, let's just check this other thing. Let's see if there's anything you want to talk about here first. Savannah Chrisley. Oh, the Chrisleys are out. They're out. Okay. Okay. Bindi Irwin shares an update on her crippling endometriosis journey. 2 weeks after emergency surgery. Huh. All right, well, the death of 18-year-old kayaker. A jet ski hit and run. It's terrible. How old is Jessica Parker? I haven't seen her in a while. Okay. All right, let's get on to... Let me pull up. Okay, so what I'm going to have to do here, hold on a minute, is there's nothing really that I need to redact, but I will just read this because I didn't put these into anything, and I'm just going to read you these court documents filed by my attorney. On time. Okay, let me go over here. So that you guys are the one thing, okay, here, so you understand this. Heather and her attorney were asking the judge, okay, this is a copyright case, which means that if it's a copyright case, it is going to a jury, right? Doesn't the jury need to see the videos in question? Well, Heather and her attorney did not want the jury to see the videos in question because they said it would bias the jury. So what does that mean to you? How would a jury even be able to look at a case like this without even seeing the videos, right? So they didn't want them to see the videos. And they put a motion in to bar that. Okay, so the first thing that I'm going to read to you is my attorney's response to that motion in limine. So this is the defendant, me, is the opposition to the plaintiff's first motion in limine. Okay? So it says the defendant, Carolyn, me, submits the opposition to the plaintiff's motion in limine to bar the introduction of evidence or discussion at trial concerning the contents of videos that Carolyn reported to YouTube under the DMCA. DMCA is a takedown. It means that that's what a copyright owner files through YouTube when their content has been taken and used without permission. Okay, that's what we file, a DMCA. Rule 402 of the Federal Rules of Evidence provides that all relevant evidence is admissible, except as otherwise provided by Act of Congress or by these rules. Evidence which is not relevant is not admissible. Federal Law Evidence 402. The standard of relevance established by the federal rules of evidence is not high. United States versus Southland Corp. Evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence is relevant. Okay, the genesis of this action is the 20 videos identified by title in the complaint. Okay, so they're talking about 20 videos that Heather put in her complaint that she no longer wants the content to be shown to the jury. So that's what he's talking about here. Is the 20 videos identified by title in the complaint that Kavarnos is alleged to have knowingly misrepresented as infringing her copyrights, because that is what she's claiming, that I misrepresented this, okay? Heather admits the 20 videos named in the complaint did infringe my copyrights by taking issue only with Carolyn's alleged failure to consider the fair use doctrine. So what my lawyer's saying is, in her complaint, she admits that those 20 videos did infringe my copyright, which means that I was right. Do you understand that they did infringe on my copyright? Because the only thing that she mentions is that she doesn't think I considered fair use before I filed the DMCA takedown. That's what he's saying right there, okay? It says Heather has never alleged that Carolyn was not entitled to submit the takedown notices against any of the 20 named videos as copyright holder. Therefore, the content of the 20 videos and the content of any takedown notices is absolutely relevant to the determination. For example, if Kavarnos accurately described the offending video in a takedown notice, that would tend to prove she considered the fair use doctrine prior to submitting the takedown. Thus, the content of the videos is absolutely relevant to the determination. Carolyn did not lie in her answer, nor can she even be impeached by denials in a legal pleading. Carolyn legitimately filed takedown notices to protect her original content, which Heather reposted without Carolyn's authorization. Heather does not want a jury to know the truth, that Heather regularly infringed Carolyn's copyrights by reposting Carolyn's original content without authorization, exactly as reported in the takedown notices. There is no prejudice to Heather should the videos that Carolyn allegedly misrepresented were infringing are viewed at trial. For the reasons stated, the court must deny the plaintiff's first motion in limine and permit the jury to view the content of the videos named in the complaint. Respectfully, and that's my attorney. And then it says it was served on her attorney. Okay, so that's the number one thing. That's about the motion. That's the response to the motion that her attorney made, wanting to bar the content of the videos. Do you guys understand that? Where the heck are you guys? Okay, over here. Let me see here. Go to live chat. Okay. She needs to learn a good, little lady said she needs to learn a good, healthy lesson along with her friends. Locked over there, staying away. Gail says, Heather's acknowledging guilt even before you enter the court. That's crazy, little lady says. Okay, so you understand all that? Yeah. Okay, so that's my attorney's response to that. It makes no sense. Think about being on a jury and you're saying, okay, well, did something infringe this copyright? Let me see about, oh no, you can't see the content of the video. Why can't I see the content of the video? Oh, because, it could bias you. Why would it bias? Like, what's the thing? Scooter, they're not going to stop lying. That's what they do best. That's their whole MO. Okay, so that's the first thing. Now the second document. Hold on, I'm just pulling it up. Okay. So this next document, make this a little larger so I can just read this right here. Filed on May 27th, is the defendant's notice of a motion for judgment on the pleadings pursuant to Rule 12C. Okay, so let's do okay. Now, Rule 12C can help dispose of baseless claims or defenses when the formal pleadings reveal their lack of merit. Lack of merit. Okay? Why did I just have that? Is this, what the heck? Okay. So this is, please take notice that the undersigned attorney for defendant Carolyn will move before the Honorable Kenneth M. Karras, United States District Court Judge for the Southern District of New York, and then it gives the address, for an order granting dismissing the plaintiff's complaint with prejudice for failure to state a cause of action pursuant to Federal R. Civil P12C, the motion. This motion is supported by an accompanying memorandum of law and declaration of counsel. My lawyer signs that, and then the memorandum of law in support of the defendant's motion for judgment on the pleadings. It says the defendant, Carolyn, submits this memorandum of law in support of her motion for judgment on the pleadings pursuant to what I just told you about the motion. Preliminary statement. Carolyn is a YouTube content creator, afforded copyright protections in her original works of authorship fixed in any tangible medium of expression. 17 U.S.C. 102A under Section 512C3A of the Digital Millennium Copyright Act, DMCA. Copyright holders, like Carolyn, may notify the YouTubes of the world when their sites are hosting or providing access to infringing content by submitting a notification of claimed infringement, commonly referred to as takedown notices, 17 U.S.C. 512c3. To be effective, a takedown notice must substantially include the following information: a physical or electronic signature of a person authorized to act on behalf of the owner of an exclusive right that is allegedly infringed, identification of the copyrighted work claimed to have been infringed, or if multiple copyrighted works at a single online site are covered by a single notification, a representative list of such works at that site, identification of the material that is claimed to be infringing or to be the subject of infringing activity, and that is to be removed or access to which is to be disabled, and information reasonably sufficient to permit the service provider to locate the material, meaning that if you create exclusive original content, you're protected on these sites like the YouTubes, and if someone is taking your content and using it without your permission, you can file these takedown notices, and this is what they need to include. They need to include, that's why you have to put timestamps and where your content is and all of this stuff and your signature, and then you have to certify that you have considered fair use and all of this, right? Okay? Then the next thing is information reasonably sufficient to permit the service provider to contact the complaining party, such as the address, telephone number, and if available, an electronic mail address at which the complaining party may be contacted. And then a statement that the complaining party has a good faith belief that use of the material in the matter complained of is not authorized by the copyright owner, its agent, or the law. And then a statement that the information in the notification is accurate and under penalty of perjury that the complaining party is authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. That's how you submit a takedown notice when your material is taken without your permission. And then he says C 17 U.S.C. 512c3a 126 cites a case. Okay, we're not going to go into all the cases that are cited. He's got a lot of cases cited here. It is well settled that the overall structure of 17 U.S.C. 512 supports the conclusion that 512c3a5 imposes a subjective good faith requirement upon copyright owners submitting DMCA takedown notices. Okay, see Rossi versus Motion Picture Association of America. The DMCA and relevant case law make clear that the threshold standard for the imposition of liability under 512F is intentionally high. See Rossi, another one. And then it says, rejecting the lesser objective reasonableness standard as inconsistent with Congress' apparent intent. As discussed herein, this requires the proponent of the claim to show a knowing material misrepresentation, which means that there was actual knowledge of misrepresentation. That showing must be supported by substantial evidence. So in other words, if you're going to accuse somebody of knowingly misrepresenting a takedown notice, like you're doing something maliciously wrong, that you don't have any good faith belief that it is infringing your content or anything like that, that the person that's saying this about you needs to submit substantial evidence to support that. Okay? Thus, a copyright owner cannot be liable because an unknowing mistake was made, even if the copyright owner acted unreasonably in making the mistake. Okay? The subjective good faith requirement also demands that Heather sufficiently allege the actual knowledge element of her 512 claim, i.e., that Carolyn knew the videos were not infringing when submitting the takedown notice. And it says, see Motion Picture Association of America, Inc. versus Rossi, and it gives that again. And then Lens versus Universal Music Corp. And then it gives Cabell versus Zimmerman. And it says, in every jurisdiction, Heather has failed to allege even the necessary elements of a 512F claim. On November 15th of 2023, the plaintiff Heather filed a one-count complaint, ECF number 1, the complaint against Carolyn to recover damages associated with Carolyn's repeated and unjustified submissions of DMCA takedowns concerning Heather's videos hosted on the YouTube platform. See complaints ECF number 1. And this is what her complaint said. Both parties operate channels on the YouTube platform. Schaefer's YouTube channel is Held to the Know, while Carolyn's channel is named Mommy Ramblings Blog. Carolyn is active on the YouTube platform, regularly posting hours-long videos or live streaming. Much of Carolyn's content focuses on true crime coverage and commentary. Carolyn also posts content on live trials, shopping, do-it-yourself projects, home improvement, and craft tutorials. Carolyn has over 42,100 subscribers and generates revenue from the Mommy Ramblings blog channel. This is her complaint, which she says here. In 2022, Carolyn began a campaign attacking Heather's YouTube channel to uncover her identity. Okay, not true. Carolyn reported a video entitled, Jimmy Falls, Poor Merb, Subscribe, under the DMCA, claiming it was infringing Carolyn's copyrights. Carolyn did not consider whether any supposed infringement of the above video was protected by fair use doctrine. YouTube took down the video, Jimmy Falls, and issued Heather a strike. On March 30th, 2022, Carolyn reported the videos entitled Jimmy Falls, Poor Merb, Subscribe, Around and Around We Go, Tammy McD, 17, Needs Attention, Czechoslovakia, WTF, hashtag Merb, hashtag Mommy Ramblings, hashtag Natasha, Napkin Gate 2022, Your son said he did not know how to pray, but you never talk about my kids, right? But you had to admit it to the court because that was the title of your video. And you were calling out my minor son, right, Heather? Right. That's why you don't want that content shown, because you called out my minor son and bullied him. And when I asked her to take down that video, you wouldn't do it. But you don't talk about kids. Forgot. But you must be truth tellers. But no, this is your filing, right? Your son said he did not know how to pray, and part 2 of Marie Osmond under the DMCA, alleging that they were infringing Carolyn's copyrights. Carolyn did not consider whether any supposed infringement of these videos were protected by the fair use doctrine, and YouTube disabled Heather's account. 2 weeks later, Carolyn reported videos entitled How Dare You, Merb, and Danger, Fire, Protect with Merb, and then No Words, and then Who Gives a Flip, and Circling the Drain Part 1 under the DMCA, alleging they were infringing my copyrights, Carolyn's copyrights. And then she again alleges that Carolyn did not consider whether any supposed infringement of these videos was protected by fair use doctrine. And YouTube assessed 4 strikes against Heather's account and scheduled it to be disabled. In September of 2022, Carolyn reported videos, How Dare You Merb and Who Gives a Flip, under the DMCA, alleging that they were infringing Carolyn's copyrights. Carolyn did not consider whether any supposed infringement of these videos was protected by the fair use doctrine. Those are her words, not mine. Because I most certainly did consider that. Unbelievable. And I attested to that and signed that under penalty of perjury. YouTube assessed strikes against Heather and scheduled Held to the No to be disabled. In late September 2022, Carolyn reported videos entitled How Dare You Merb, Who Gives a Flip, Danger, Fire Project with Merb, No Words, and Circling the Drain Part 1 under the DMCA, alleging they were infringing Carolyn's copyrights. Carolyn didn't consider whether any supposed infringement of these videos was protected by the fair use doctrine. This is her alleging this, okay? So you know this is not what happened. Carolyn knowingly misrepresented that Schaefer's videos infringed Carolyn's copyrights. At a minimum, Carolyn failed to consider whether any of Heather's infringing conduct was subject to fair use doctrine, and Heather was damaged by Carolyn's false statements in that her revenue realization from YouTube decreased. Interesting. The revenue, remember, $100,000. Okay. Legal standard. Carolyn is entitled to raise her failure to state a cause of action defense via either a motion for judgment on the pleadings or summary judgment. Federal R, Civic P8, 12N, 2B, and 56 motions for judgment on the pleadings are governed by the same standards applicable to Rule 12b-6, motions to dismiss for failure to state a claim upon which relief may be granted. Cleveland versus Cap Law enters, and that's cited. Federal Rule of Civil Procedure 8A2 always requires a short and plain statement of the claim showing that the pleader is entitled to relief. In order to give the defendant fair notice of what the claim is and the grounds upon which it rests. Bell Atlantic Corp. Versus Toombly. A complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Ashcroft versus Iqbal, quoting Bell Atlantic Corp. Versus Toombly, a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct that's alleged. Although courts must draw all reasonable inferences in the plaintiff's favor, they are not bound to accept conclusory allegations or legal conclusions masquerading as factual conclusions. Faber versus Metro Life Insurance Company. That's another case that's quoted there. Where a particular state of mind is a necessary element of a claim, a plaintiff pleading of that state of mind must be plausible and supported by factual allegations. Biro versus Condé Nast, and then it's another one, bunch of other cases here. Plaintiff's complaint fails, there's the argument, to state a cause of action under 512F of the DMCA. If Heather's allegations were true, the complaint would still fail to state a cause of action under 512F. Heather totally fails to allege the actual knowledge element of her 512F claim and fails to plead factual content from which this court can draw a reasonable inference that Carolyn is liable for knowing misrepresentations of fact contained within takedown notices submitted to YouTube. Statements by copyright holders submitted to service providers in takedown notices are subject to the provisions of 512F of the DMCA, which states, misrepresentations. Any person who knowingly, materially misrepresents under this section that material or activity is infringing shall be liable for any damages, including costs and attorney's fees incurred by the alleged infringer as the result of the service provider relying upon such misrepresentation in removing or disabling access to the material or activity claimed to be infringing. 17 U.S.C. 512F. As a threshold matter, the misrepresentation must be made in a takedown notice governed by 512 to be actionable. In addition, the purpose of all takedown notices is to alert a service provider that some content is infringing. Thus, to plead a proper 512F claim, plaintiffs must allege that the defendant represented that certain online material infringed its copyright, that representation was inaccurate, e.g., the material was actually non-infringing, and C, the misrepresentation was material, and D, the misrepresentation was made knowingly, E, relying on the defendant's willful misrepresentation, the service provider removed or disabled access to content in question, and F, the plaintiff incurred damages as a result. C, Rossi versus Motion Picture Association of America. C, Lenz versus Universal Music Corp. C, there's another Hassan Daffer, whatever, versus Klein. I'm not even going to try to pronounce that name. Paul Rudolph Foundation versus Paul Rudolph Heritage Foundation. See also National Academy of Television Arts and Scientists versus Multimedia System Design, Inc. Okay? Finding allegations that defendant misrepresented to YouTube that the plaintiff's content was infringing and that the defendant had actual knowledge or with reasonable diligence could have obtained knowledge that this DMCA takedown notice had no merit to be conclusory and insufficient to state a 512F claim. Emphasis added. In the Second Circuit, to satisfy the actual knowledge element, plaintiffs are required to allege facts supporting an inference that the defendant had actual knowledge, i.e., that the defendant knew that they were making a material misrepresentation. And he lists another number of cases, 4, 5, 6 cases. A copyright owner cannot be liable simply because an unknowing mistake is made, even if the copyright owner acted unreasonably in making the mistake. Here, the 50 paragraphs of Heather's complaint, 50 paragraphs, cannot state a valid cause of action under 17 U.S.C. 512F. The complaint incorrectly claims that 15 U.S.C. 512F creates the cause of action now pled against Carolyn. However, 15 U.S.C. 512F has never been enacted, so it cannot serve as a basis for the claim. Regardless, had 17 U.S.C. 512F been properly asserted, Heather's claim still fails. The allegations do not establish specific facts or information allegedly misrepresented by Carolyn in a relevant takedown notice, nor the specific person or entity receiving the takedown notices. Other than the reporting date and video titles, no facts are provided for the allegedly infringing content. Carolyn cannot be liable under 512F unless the alleged misrepresentations were contained within a notification of claimed infringement submitted to a service provider. See 17 U.S.C. 512 C3A. Also, there is no factual content alleged from which this court can infer that Carolyn had actual knowledge that the various videos named in the complaint did not infringe Carolyn's copyrights when submitting the takedown notices. Under well-settled law, Heather has insufficiently alleged the actual knowledge element of a 512F claim, i.e., that Carolyn knew the plaintiff's videos were not infringing when filing the takedown notices. See Motion Picture Association America, Inc. versus Rossi, and then the Lens again, and a bunch of other cases. Since the purpose of all takedown notices by design is to claim that some content is infringing, no specific factual support can be gleaned from Heather's allegations that Carolyn reported videos under the DMCA alleging they were infringing Carolyn's copyrights. Heather's general allegation that Carolyn knowingly misrepresented that Heather's videos infringed Carolyn's copyrights is an insufficient formulaic resuscitation of 512F statutory text couched as a factual allegation. And then it has White versus UMG Recordings, Inc. And actual knowledge cannot be inferred from a disconnected allegation that Carolyn began a campaign attacking Heather's YouTube channel to uncover Heather's identity. Okay? Actual knowledge cannot be inferred from a disconnected allegation that Carolyn began a campaign attacking Heather's YouTube channel to uncover Heather's identity. Likewise, allegations that Carolyn failed to consider the fair use doctrine are insufficient, sounding in negligence, which is not the standard for liability under 512F. And then again, there are more cases here: White versus UMG Recordings, Cabell. Let's see. Second Circuit courts require plaintiffs to show actual knowledge. Negligence is not the standard for liability under 512F. And then he adds some more cases here: Crosley, Cochran, Tudor. Heather will undoubtedly rely upon the inapplicable dictum holding of the Ninth Circuit in Lens versus Universal Music Corp. The reliance on Lens is well and truly is misplaced. The Lens decision applied a summary judgment standard to the merits of a 512F claim. Lens did not determine, as suggested by Heather throughout, that a failure to consider fair use constitutes a knowing misrepresentation under 512F. Rather, Lens reiterated Congress's intent, as first announced in Rossi, that only a subjective good faith belief standard be imposed on copyright holders by 512F, and that copyright holders could only be liable upon substantial evidence of some actual knowledge of misrepresentation on the part of the copyright owner, Lens versus Universal Music Corp. Even the Lens court would dismiss the plaintiff's complaint, that's Heather's, for insufficiently alleging the actual knowledge element of a 512F claim. Lens undermines the legitimacy of Heather's claim by requiring far more elaborate allegations than those found in the instant complaint to successfully state a cause of action against a copyright owner under 512F. Lenz required extensive allegations of bad faith and deliberate ignorance of fair use before finding the 512 claims survived a motion to dismiss. Lenz versus Universal Music Corp. In fact, the Lenz decision is premised upon the following allegations as to actual knowledge. Plaintiff alleges that the defendant is a sophisticated corporation familiar with the copyright actions and that rather than acting in good faith, the defendant acted solely to satisfy Prince. Plaintiff alleges that Prince has been outspoken on matters of copyright infringement on the internet and has threatened multiple suits against internet service providers to protect his music. Plaintiff also alleges that the defendant acted to promote Prince's personal agenda and its actions have nothing to do with any particular YouTube video that uses his songs. Defendant and or their representatives viewed the Holden dance video and decided to issue a DMCA takedown notice despite their knowledge that the use of the Prince song in the video was a non-infringing fair use. Defendant sent the DMCA notice at Prince's behest, based not on a particular characteristic of the Holden video or any good faith belief that it actually infringed a copyright, but on its belief that, as a matter of principle, Prince has the right to have his music removed. The Holden dance video does not infringe any copyright owned or administered by defendant's use of Prince's song, Let's Go Crazy, in a self-evident non-infringing fair use 17 U.S.C. 107. On information and belief, defendants had actual subjective knowledge of the contents of the Holden dance video, and that it did not infringe any defendant's copyrights on the date they sent the YouTube the takedown notice regarding the Holden dance video. With the actual subjective knowledge, defendants acted in bad faith when they sent the takedown notice, knowingly and materially misrepresenting that they had concluded that the video was infringing. In the alternative, defendants should have known, if they had acted with reasonable care or diligence, or would have had no substantial doubt that they had been acting in good faith, that the Holden dance video did not infringe any defendant copyrights on the date they sent YouTube their complaint under the DMCA. And defendants violated 17 U.S.C. 512F by knowingly, materially misrepresenting the Holden dance video infringed copyright. That's what she's citing, okay? So my lawyer is putting that in there and noting the differences in that case, okay? See Lenz versus Universal Music Corp. 572F, Supplemental 2D 1150, 9th Circuit, 2008. He says, in stark contrast to the robust allegations of Lenz, Heather's factually barren, meaning without facts, factually barren complaint has just one allegation containing the word knowingly. See complaint ECF number 148. This lone allegation that Carolyn knowingly misrepresented that Heather's video infringed Carolyn's copyrights is nothing more general legal conclusion improperly couched as a factual allegation. Again, he quotes Ashcroft versus Iqbal and Bell Atlantic Corp versus Toombly. Actual knowledge cannot be reasonably inferred from mere allegations that Carolyn began a campaign attacking Heather's YouTube channel to uncover Heather's identity. So, actual knowledge, you're saying that if you're saying that I misrepresented and that your actual knowledge of that is that you say Carolyn attacked Heather's YouTube channel, actual knowledge cannot be reasonably inferred from allegations, mere allegations, that Carolyn began a campaign attacking Heather's YouTube channel to uncover Schaefer's identity. Most important to the issue, under binding Second Circuit case law, mere allegations that Carolyn failed to consider the fair use doctrine are insufficient, sounding in negligence, which is not the standard for liability under 512F. And then he lists numerous other cases. Conclusion. In conclusion, Heather fails to state a cause of action against Carolyn. Without alleging actual knowledge or factual content sufficient to support the claim, the court cannot impose liability upon Carolyn under 512F of the DMCA. No court has found such deficient allegations to successfully state a cause of action against a copyright owner under 512F. Therefore, Kavarnos is entitled to a judgment of dismissal with prejudice on the pleadings pursuant to Federal R. Civic P. 12C. The undersigned certifies the document was served by electronic mail to her attorney. So those are the new filings. And let me go back here. And, you're free to go take a look at them, look up all those cases, look this up. But what it's saying is she hasn't shown the cause. She hasn't, you can't just say, oh, she didn't do this, and then just point that, she started attacking the YouTube channel. That's not a cause of action. You've got to state a cause of action against me, and Heather fails to state a cause of action against Carolyn without alleging actual knowledge or factual content sufficient to support the claim. The court cannot impose liability upon Kavarnos under 512F of the DMCA. So, where the heck are you guys? Is it here? Thanks for sharing that with us, Carolyn. You're welcome. Hey, Victoria. How are you? Let's see. Message the wedding says, I think the case, whoever wins, the other side will appeal it. And I think it's going to make its way all the way up to the Supreme Court. I don't think there's going to be full resolution for years. Hi, Murder of Crows. Hi, Cato. So Heather's trying to get money. And, oh yeah, $100,000, a Murder of Crows. $100,000. What is even the basis of that? What is even the basis of that when her YouTube channel didn't even pass the threshold to be paid by YouTube? She does admit she just pulled that number out of the air. $100,000. No basis whatsoever. See, it's the jury's job to see and evaluate the evidence. It's very telling that they don't want it to be shown. Yeah, exactly, Mary. And how would you, as a juror, be able to determine copyright if you couldn't even see the videos that I said were infringing my copyright, right? How could a juror even begin to decide a case like that? What were they so afraid of? The jury needs to see the videos. Absolutely. Jody, hello there, Jody. She wouldn't have made $100. It's pure greed. Absolutely, Murder of Crows. It's well documented. Heather should have dropped this and moved on. It's all about money, I think. It's more than about money. It's more than that. It's a good deal about money, but it's more than that. Yeah, Murder of Crows. There's all kinds of things about like what the attorneys can be liable for if they take a case like without merit, a frivolous suit. Yeah, there's a lot of things that they can be on the line for. Yeah, absolutely. Yes, we'll see what it is. It'll be decided by the judge. Carolyn. No, you don't. It's not a counterclaim, White Angel. You put in the other filings about frivolous lawsuits and all of that stuff. It doesn't have to be a counterclaim. Look up frivolous lawsuits, White Angel, and what happens to counsel that takes them on. But I'm not going to say any more on that because that's certain aspects of the case I'm not going to discuss now. So yeah, there's a lot of lies out there. I mean, it's just it's outrageous. It's outrageous. And that's not going to happen to Scooter because they're not in charge of that. Okay? They think they are. They don't have any charge of this channel. You think they would know that by now? But some people were obviously very triggered tonight. Very triggered. That they were just behind that keyboard making profile after profile. Who said that? Who said the jury needs to see the videos? What are you talking about, White Angel? My lawyer responded to Heather's lawyer asking the judge to not show the videos to the jurors, not show the videos in question to the jurors, to exclude that evidence. Her lawyer asked for that, White Angel. My lawyer said, how could you do that? That's relevant evidence. How could a jury even go to decide a case where you don't allow the videos in question to be entered into evidence? Someone just trying to make trouble and disturb your peace because they have none. I hear you, Victoria. Cato says, Victoria, you're right. Yeah, it's, that will never happen. Why would they even put that in there? You know what I mean? That's like, the jury needs to see them. In other words, White Angel, of course. How could you be a juror on any case? Oh, here, let's see. Here, you're deciding a copyright case. Okay, all right. This woman filed a DMCA on this video. Oh, can I see that video? No. Oh, why not? Oh, because the plaintiff's attorney doesn't want that admitted. The plaintiff and her attorney don't want that admitted. Well, then how the heck am I going to see if the defendant's copyrighted work is in there, and I want to look at the timestamp she put in her DMCA, and I want to look at that, but you're saying I can't see the video? Come on. She's seeking $100,000. What I meant was, are you seeking $100,000? I told you I cannot discuss any of that, White Angel. I cannot discuss any parts of that. Little lady says, seems to me she's not so bright. Little lady, Victoria. I mean, yeah. And you know the reason, right, that they don't want the jury. Why do you think they don't want the jury to see the videos? Why would you think that? I mean, why would anybody not want the jury to see the evidence? Right? If you're claiming that the DMCAs were, misrepresented, why wouldn't you want the jury to see the video? Why? Why would you ask for that to be excluded from the evidence? Why? Exactly, to Scooter. Why would you? If you're so confident that, but see, that's what they're saying. The own claim doesn't say that the videos were not infringing. That's you've got to really read this, and it takes a few times to go through it. And I know it's like could get boggling. If you want to read it on your own, go ahead, go and look up the cases that are cited. But yeah, why would anybody ask for the evidence to be suppressed? That makes no sense. That would probably be more troubling to the jurors. Like, well, why can't we see the video? Well, because the plaintiff filed a motion not for you not to see it. Why? That to me sounds. If I was a juror, what would you say as a juror? You're supposed to be deciding a copyright case, but you can't see the video. Does that even make any sense to you? Well, that's my lawyer's answer to their motion to suppress the videos, saying that you can't. That's relevant evidence. Bill says it's ridiculous to request to not have them shown. How would there, and to decide without them? How could you? Because if you looked at a DMCA, when you look at a DMCA, it gives you the timestamps in a video where you submit that to whatever platform. Okay, in this case, it has to be, it's YouTube, but they have to know the timestamps of where you're saying that your copyrighted contents, your exclusive content, was taken without permission and it was used in these timestamps. And if that can't be shown, if I was a juror, how could I even make a decision? I just something. I just game. Oh, it's a he said, she said game if you don't show evidence. How could a jury even... Can't even imagine. It's like, is there any case ever that is about copyright and they've suppressed the videos that the DMCAs were issued against? I mean, I don't know of any. Do you? That's like, to me, it's... Oh, your hands are playing up. Sorry. That's all right. How could, doesn't make sense. Does not make sense. Does not compute. Does not compute. Oh, yes. On a DMCA, you have to give the timestamps. Exactly. Exactly, Scooter. That's how they determine. You have to give the exact timestamps. Absolutely. How would anybody... I don't even see how they would even... Let me go to that filing. Hold on a minute. Where they asked for that, okay? Let's look at that filing where they asked for that to be suppressed. Hold on. And see, and we'll get the exact reason that they put that in there, okay? Okay. Okay, hold on. Let me see if this is the one. Oh, here it is. Plaintiff's first motion in limine barring discussion of video contents. Heather, by and through counsel, submit this motion in limine to bar the introduction of evidence or discussion at trial concerning the contents of videos Carolyn issued takedown notices on. Okay, let's get that again. Heather, by and through counsel, submits this motion in limine to bar the introduction of evidence or discussion at trial concerning the contents of videos Carolyn issued takedown notices on. And it says, introduction, the case is going to trial on a narrow issue, whether Carolyn adequately considered in good faith fair use when issuing DMCA takedown notices on Heather's videos. This motion seeks to limit the introduction of evidence about the contents of those videos. Now listen to what they said. It is irrelevant, as Carolyn admitted. Second, now it is irrelevant as Carolyn admitted? What? Second, any small degree of relevance is highly, unduly prejudicial. Highly, unduly prejudicial. Irrelevant evidence is not admissible. See? And my attorney says, this is relevant. And then he goes on about that. Let's see. The contents of the video are not relevant to the sole issue, whether Carolyn adequately considered fair use. Let's see. Then it said, yes, all evidence is prejudicial to some extent, but Rule 403 weeds out unfair prejudice. Even if there were some small degree of relevance to what the videos consisted of, it would be unfairly prejudicial, confusing, and wasteful of the court's time. Oh, then it says, listen to this one. The contents of the videos, which Carolyn suggests are harassing, will only cause juries to focus on the Heather-Carolyn relationship and the nature of the videos, not whether Carolyn adequately considered fair use. So he's saying the content of the videos, which Carolyn suggests are harassing, will only cause juries to focus on the Carolyn-Heather relationship and the nature of the videos, not whether Carolyn adequately considered fair use. Then it says, Heather's characterization of Carolyn's character can only inflame a jury, distracting it from the actual issue in the case. It has nothing to do with whether fair use was considered. Any arguable modicum of relevance is outweighed by prejudice. And it said, for these reasons, Heather requests the court bar evidence or discussion of the contents of Heather's videos that were subject to the takedown notices. So that's what my attorney, that first document that I read, was in response to that. And that's this one, where my attorney says, Defendant Carolyn submits the opposition to plaintiff's motion in limine to bar the introduction of evidence or discussion at trial concerning the contents of videos that Carolyn reported to YouTube under the DMCA. Rule 402 of the Federal Rules of Evidence provides that all relevant evidence is admissible. The genesis of this action is the 20 videos identified by title in the complaint that Kavarnos is alleged to have knowingly misrepresented as infringing her copyrights. Heather admits the 20 videos named in the complaint did infringe Carolyn's copyrights by taking issue only with Carolyn's alleged failure to consider the fair use doctrine. Heather has never alleged that Carolyn was not entitled to submit takedown notices against any of the 20 named videos as copyright holder. Therefore, the content of the 20 videos and the content of any takedown notices is absolutely relevant to the determination. For example, if Carolyn accurately described an offending video in a takedown notice, that would tend to prove she considered the fair use doctrine prior to submitting the takedown. Thus, the content of the video is absolutely relevant to that determination. Carolyn did not lie in her answer, nor can she even be impeached by denials in a legal pleading. Carolyn legitimately filed takedown notices to protect her original content, which Heather reposted without Carolyn's authorization. Heather does not want a jury to know the truth, that Heather regularly infringed Carolyn's copyrights by reposting Carolyn's original content without authorization, exactly as reported in takedown notices. There is no prejudice to Heather should the videos that Carolyn allegedly misrepresented were infringing are viewed at trial. For the reasons stated, the court must deny plaintiff's first motion in limine and permit the jury to view the content of the videos named in the complaint. So you see how ridiculous, right? Hey, cheek pinching granny, how you doing? How many years have they attacked Carolyn? If you don't like someone, then just walk away. Move on. Don't watch. I'm at a loss why they keep carrying on like this. You and me both, the murder of crows. It's an obsession that is really scary. And you really have to wonder what their life is like. That day in and day out, this is all they think about. Right? Move on. Move on. Move forward. Don't watch. Crazy. Crazy. They must lead very boring lives. I think that's worse than boring. I think it's worse than boring, Murder of Crows, because I think you have to be an extremely bitter, unhappy, envious, vengeful, evil person to do what the things that have been done consistently, and hours and hours and hours and hours and hours and hours and hours, day after day after day after day after day, year after year after year. Hi, cheek pinching granny. Hi, Mrs. Mick Jagger. How are you? I haven't seen you in a long time. How are you doing? You understand this, Mrs. Mick Jagger? You understand why people can't move on? Why can't people move on, Mrs. Mick Jagger? Do you understand it? It's like having a bunch of stalkers. It's totally having a bunch of stalkers. That's all they do is stalk. But a Murder of Crows, it's like anybody having that amount of hate and vengefulness inside of them, they don't know what it's doing to them, okay? And what it's doing to them. And yeah, and what it says about them. That's the thing they have no self-awareness at. What all that is doing to them and what it shows other people. They are 100% stalkers. They watch every single thing, Murder of Crows, more so than anyone that truly likes you to watch you for content, because they're watching with a different thing in mind and they can't get you out of their mind. You know, I live in every one of their minds. I'm the first thing they think of when they get up in the morning and the last thing they think of before they go to bed. They can't be in any chat whatsoever without talking about me. Ever. I will always come up. Some more than others. Some just can't even get my name out of their mouth at all. If no self-awareness, then you've got zero accountability. Yeah. It's quite something. Her videos represent hate and grade school behavior. I can't imagine what her attorney thought when he viewed them. What an embarrassment. Well, apparently enough to want to file that motion that they're barred from being discussed at trial and they're barred from being shown at trial and introduced into evidence. How can you have a copyright trial and bar the very videos that the DMCAs are filed on? I mean, just think of that. Just try to rationalize that. You know what I mean? I mean, just... And what it says to the judge, just the filing, what it says to the judge. Can't go exactly why. Like, crazy. How? Okay, jurors, yeah, could we see the videos in question to see where the content was? No. Could you? No, we can't discuss that. No, that all that is barred. Every single copyright case you hear of, right? Every one that is ever cited, you see both sides of it. You see the video where the alleged infringing content is, and you see the content, the original content. Tell me a copyright case that the alleged infringing content is barred. Tell me one that is barred. Right, murder code. Can we see the evidence? No. No, it's not relevant. It's irrelevant. How is it irrelevant? Isn't this where we have to know? Isn't that where the DMCA was filed on? Yeah. So I'd like to see that video. No. I mean... Why even file that? I mean, it's... Yeah, do not ask for evidence. How can the jury make a decision without seeing the evidence? It's ridiculous. It is, Murder of Crows. They want you to... Okay, they say not to show the evidence, not to discuss the videos. They would only know, I guess, the length of a video and where the content was in there. But they would not be allowed to see the video or discuss its content. Yeah, no soup for you. Yeah, I just think that would be probably even more that the jurors would be like, what? They would imagine, wouldn't they be imagining the worst? Like, why can't we see the video? Why can't we see the content? Why can't we discuss the content? Why can't we know what the video was about? withholding that is probably even worse. I thought you needed to provide evidence to support your case. Yeah, right? Why would they ask to suppress that, Victoria? To bar that? Oh, here's like every judge is like, you're going to have all this evidence to take back with you to the jury room to do your deliberations. I'm sorry, you're not going to be having any evidence to bring back with you to do your deliberations. I meant when I left a comment on one of her videos, she said that someday she will own 2 lake houses. What a sick woman. I meant when I left a comment on one of her videos, she said that someday she will own 2 lake houses. What a sick woman. That doesn't even make sense, Rosalita, okay? Because how's she going to own 2 lake houses? How's she going to own 2 lake houses? There was another psychologist on YouTube that used to say that too. Okay? She's not really thinking too clearly, I don't think, if she said that. How's that going to happen? Rose Lydia says she will never own 2 lake houses, let alone her own. Right. Yeah, that's like really crazy to say. And why doesn't she just do something in her own life if she wants to own a lake house? Maybe, I don't know, work or something? Instead of, well, the way I have the quote that says, taking me down was her job. And it was God's work. I don't think God has anything to do with this at all. If you want to own lake houses, Heather, you should maybe concentrate on doing something of value on your own. God doesn't work like that. Yeah. Yeah, right, Murder of Crows? God's work. I don't think so. You know, if she owns 2 lake houses someday in the future through hard work, good for her. Go own 3 or 4 through hard work and legitimate stuff. Good for her then, but to say it for this is just crazy, because that doesn't even make sense. It's not even feasible, Scooter. Not even feasible. You're suing someone for $100,000 and then you're saying you're going to own 2 lake houses. Tell me how that even makes sense. Obviously, she doesn't know the value, and she doesn't know the law. Have they never heard the saying, live and let live? I don't think probably that they have a life. Because I don't know how anybody that does have one could invest this amount of time into nothing but hate. If you go way back in our emails, Carolyn, I have even sent you a copy of that comment. Oh, I'm sure I have it then, Rosalita, because I don't delete any emails. I keep everything. So I'll check that out. Thank you. I'll check that out. I have, like, sometimes I forget all the screenshots and everything I have of things that have been said. It's incredible. It's like that person that's going by my house multiple times and now trying to twist her way out of that and saying, no, I just went by the exit on the highway. No. That's not what you said. And you also said stuff about stalking my son at his restaurant. And I have all of that, honey. Okay? So now you want to get out of it and say, oh, no, I just passed the exit on the highway. No. It's not what you said. And remember, I have cameras all around my house. Yeah, I'll have to check that out. So crazy. These are the sun and moon stones that Sandy and I got in Edisto at the Marsh Moon Cafe. She has the right to sue you over using the content. Murder of crows. Do you know, I'll just say that when somebody does something, not for a reason that they should, but as another reason. That's what a little birdie told me. To me also, murder of crows. And the thing is, if you remember, her identity has nothing to do with this. Her identity has nothing to do with this because her identity was revealed through somebody we mutually knew. The screenshots of the PayPal account and everything, and her freaking out, has nothing to do, not one thing to do with DMCA takedowns. Absolutely nothing. The only reason I file a DMCA takedown is when somebody steals my content. No other reason. Unauthorized use of my content, my exclusive content. And I've never wavered from that, ever. But every time court documents are read and anything is from my attorney, it's all skimmed over. And it's paraphrased because it's not interested in truth. Only one side. You see, sometimes you watch them for a few minutes just to laugh at the ridiculousness for real. Tough talking and making up stuff and thinking they know things they don't, and how they have become everything they claim to be against. Yeah, oh yeah, it's complete projection. Complete projection. The hate bonding is really, that's really the mark of someone's character, you know? The hate bonding. Of course. No, Scooter, they go all over the place with you. It's either I have so much on Scooter, she can't do anything. I have so much on her, or Scooter's just as bad as me, or what's the other thing? Or they feel sorry for her, and but she can't go anywhere again because I've got too much on her. I hold too much over her head. What? It's so dumb, so ridiculous. But the hate bonding is something else, you know what I mean? Because it's always the same. The hate bonders always go to another community and they say, oh my gosh, oh yeah, I just saw the light. I just saw the light. I just saw it. And then it goes between I saw the light or I got tossed out, to which they say, well, if they got tossed out, then that's worse because they didn't see the light. They were so bad they got tossed out. So whatever it is, it's always lies. And the greatest lies they tell is, oh, yeah, you're right about everything, and I'm sorry, and I'm so sorry. Can I just hate bond with you? Can I hate bond with you? Yeah. It's really sad that people don't have the integrity to have a moral compass and keep that. You know what I mean? Regardless of what people fall out with what people, it's like just crazy. It's absolutely crazy. I think you've got to feel like such a skank to go hate bond, you know? They don't like you and you're okay with that. But they'd hate bond with you probably in a minute. As long as you admitted to like whatever they say that, oh, I saw the light. Oh, you're right. She had so much over me. Can I come hate bomb with you, please? And it's funny because with hate bonding, right? The people that have integrity see what's going on, and if the people know that what that person thought about those people, said about those people, and looked down on their morals, everything they did, and then they go and bond with them and say, oh, my good friend, oh, I missed you so much. What were you saying about them for months? About how they're evil and you never like them and they have no integrity, yada, yada, yada. My goodness. Pick yourself up off the ground and have some integrity. Person that does that is just scary. How could they ever be trusted? How could they ever be trusted? They have zero integrity. Zero character. Their character is non-trustworthy and just a creep. A creep. I don't even understand. It's crazy. And it's the same thing, you know. I'm so dangerous, or I did this and I did that. What'd she do? Oh, you know. What'd she do? It's either outrageous things that never happened, okay, or they don't say anything. And it's like somebody said a long time ago, and it's somebody that doesn't like me, but somebody that called out the people that were hate bonding and trying to go somewhere. And they said if they had something on Carolyn, that they really had something on Carolyn, they would have dropped it in their lap with a bow. Okay? Keep saying that they're going to go tell their story and they're going to go tell this on this channel or that channel when they're ready. BS. BS. That's all it is. BS. That makes sense. Yeah, they have something, you drop it on a big bow right on someone's lap. Good night, Carolyn and everyone. See you all next time and take care. Don't worry. It will all work out for the best. Oh, I know. I have faith in God, Victoria. I know. I know God sees this, and I know God knows the truth. I know that. And I have absolute faith in that. I've been lied about so many times, Victoria. So many lies have been said about me, about my family, about my children, about my husband. But it doesn't matter what these people say, because they don't know the truth. God knows the truth. And we'll all have to answer to God one day. So they can just keep lying. They'll have to explain it. Negative behavior is disgusting. Hours upon hours dissecting, making fun of, talking about someone that's supposedly just like they need to look within, fix themselves first. Exactly, Rosalita. And let me tell you something else, okay? There's many channels, but there's one channel in particular. I've called the channel out. They take Shanann's videos. They take Shanann's videos, innocent videos, no matter what it is that she's doing. A group of catty, bitter, jealous, lonely, hateful, vengeful women sit around and judge a murdered woman for hours. 4 hours. Think of that. Think of how disgusting that is. Like they are better than everyone, a better mother, a better this, a better that, doing it to try to say they're educating people or whatever. The craziest things. She could say it's raining outside, and they argue. Did you hear the way she said it's raining outside? It's so disgusting. It's just, I cannot even believe that our society has people that would do such a thing and go to bed at night and feel okay about themselves and justify what they're doing. These people are so perfect that they can judge someone else. Yeah. And I mean, they do similar things to me. No matter what I say, if I say on here that, oh, it's raining again and it's making me so depressed, they'll say something like, oh my gosh, did you hear her last night? She said it's raining again and she's so depressed about it. Oh my gosh, what the hell is wrong with her? She's so disgusting. They'll go on for an hour about that. Meanwhile, one of them can be like, hey, what's up today? Not much. It's raining again. I don't know if I can take much more of this. And you're like, oh my gosh, if I would say that, that would be 2 hours. Okay? But the hypocrisy is so blatant, but to them, they have blinders on. They don't even realize. Okay? It's ridiculous. They're the best mothers. Okay, even the ones that have estranged children, I guess they're the best mothers because it happened through no fault of their own. They're the best mothers. They're the best wives, even if they're not married and divorced 18 times. They know the best about everything. It's insane. This trial, no matter the outcome, will not fix their inner demons. Spend time with your loved ones, self-care, find a hobby other than talking about Carolyn. Yeah, exactly. And it's just, they started letting go, oh, even if we don't win, we won. Like they've already got their narrative down that no matter how this goes down, okay, if they lose, they won. If they win, they won. And if they lose, they won. Okay. All right. I wonder if they talk to their spouses the way they do in those chats. Or... A lot of them don't have spouses, Rosalita. A lot of them don't have spouses. I think a lot of them don't have much in their life, Rosalita, and that's why, because I cannot see somebody with a fulfilling, active, happy life engaging in this activity. Like, I can't imagine if Scooter said to me, like, hey, what are you doing today? Just getting ready for that live I'm going to do on so-and-so. You're going to talk about them for 7 hours? Yeah, you want to come talk about them for 7 hours? Okay. You think we can get a few more people on the panel to talk about that person for 7 hours? Yeah, are we going to rip them apart? Yeah, of course. All right. Then you go through 7 hours of that. Hey, what are you doing tomorrow? I don't know. I'm going to go watch that person's videos so that we can get stuff to rip them apart for another 7 hours? Yeah, that sounds fun. Okay. You think we can get 5 or 6 people on panel to do that? Yeah, of course. All right. The reason some people do that is because it makes them feel better about their own lives. And if they rip apart someone's parenting, it makes them feel better about their own parenting, even if their kids are estranged. And then I did hear this through one of them that's some kind of a counselor, that their kids are estranged from them through no fault of their own. Through no fault of their own. But that person will sit forever and talk about what a bad mother I am. And they don't talk about my kids, except they talk about my kids all the time. And they show my kids all the time. Guess we say that too, murder, remember that. What? Or murder. Or mutter. Oh. I wish I was so perfect that I could pass judgment on people. I don't really know. Exactly. And they don't really know. They don't know me. They don't know anybody. Okay? It's absolutely ridiculous. But it's such a level of obsession. It's just such a level of obsession. It's crazy. It's crazy. It's absolute insanity. It's absolute insanity. Maybe that's why I cannot relate. My husband and I have a partnership. How we treat others reflects. Exactly, Rosalita. Exactly. You have to be miserable. You have to be miserable to do that stuff. There's no way you can tell me you're a happy, fulfilled person doing that. There's no way. Absolutely no way. It's not a one-off thing where somebody gets mad and they vent. This is consistent. Year after year, year after year, month after month, day after day, day after day. It doesn't stop. It doesn't stop when they go in another chat. You can bet my name will be mentioned there. My name will be mentioned here. My name will be mentioned there. It just doesn't stop. It's not a one-off. It's not an event. It's a way of life for them. We win, we win. If we lose, we win. Right, yeah. Yeah, if we lose, we win. That, I forget what the logic on that was. If we lose, we win because we know the truth. You know? Well, Rosalita, apparently there's one person funding it. She's not funding anything. There's one person funding that. And whether she puts herself in debt or she just wastes and pisses away a substantial amount of money that could have been used for her family and for other worthwhile things, I don't think it's going to make one bit of difference to someone else because, someone else was fueling it. It's sad. It's really sad that people can't move on, right? What a waste of someone else's money. Yeah. What do they say? A fool and his money are soon parted? Um, I think the plan to get money back was through dog breeding. I don't know, someone might have told me that, or I heard that somewhere. Yeah, Scooter, I'll tell you about it later. Yep. But I can't believe what time it is. Let me do the word cookies tomorrow. What do I have tomorrow? I have something going on tomorrow. I can't remember what it is. Oh, I gotta do something with Evie. Evie, my favorite. And I think my car's got to go have its tires rotated and balanced and its oil changed. I got infused murder of crows. What's the other big one on top? What's the other one on top? Time for dinner. Why not donate to a charity? Spend your money helping people, not trying to destroy someone's life. I don't hate anyone. Neither do I, murder of crows. Hate will only destroy you. Hate will only destroy you. Unifies. Ah, yeah. Very good. Very good, thank you. Thank you. I can't believe 2 more days in the month. It's almost my birthday. It's almost my birthday. Okay. Oh, this one is driving me crazy. There's only one E though. Doter, I thought I tried that. Let me see. Yeah, that's an extra word. I got that. Your birthday month will be over then. Your birthday month will be over then. Why, when is your birthday, Gail? When was your birthday? Wait a minute, your birthday was in the beginning of May? Wait, when was your birthday? I'm so confused. I'm losing my mind. Scooter's birthday was May 4th, May 6th for Linda. When was your birthday? I'm losing it. May 1st. So it's May 1st. May 1st. Oh my goodness. Oh my goodness. Scooter's birthday month will be over too, and so will Linda's. Older. We're getting older. An otter. Oh no. Oh no. What'd I do? What did I do? It's now the 29th. Our precious Amelia would be 19. Wow, 19? I thought she was the same age as Ethan, but a year older, right? Yeah. Yeah, she's still here with me. Aw, happy heavenly birthday, Amelia. Have a good day, Evie. What's Evie having? And Minnie is 17. Oh, they share. Happy birthday, Minnie. What does it say there? Earnings upcoming. What the hell does that mean? What does that mean? I just got. I don't know what the heck. Oh, I don't know what that means. All right, let's see. What is this one? Oh, that's right. Gia wants to do something on Friday. That's what I had to do, figure out. I gotta call her tomorrow. That's the other thing I gotta do tomorrow. She just got back from France. We've got so much to celebrate. We still have to celebrate Mother's Day, her birthday. We've got to have the cake. We celebrated Michael's birthday, but we didn't have his cake. So we have to do his cake. And my daughter's birthday, but she won't be here, so we've got to do those 3 things, and then my daughter's birthday when she comes in a couple of weeks. And then my birthday. So I don't know. I gotta call her tomorrow and see what she wants to do. See what she wants to do. She got a beautiful shot of the Eiffel Tower at night lit up. A beautiful little video. Gotta put that up. All right. Where's this one? Oh, duped. Let's see. That's it. That's it. Thank you. What? Good night, Debbie 2 Scooter. Yeah, I gotta go to bed too. Spicy? Yeah. Oh, 2 Scooter chick. Hey. Did I do ship? Oh, I just did ships. Okay, we'll leave it at that one tonight. I didn't even realize that I'm a pair. I must have had an advancement. I didn't even realize it. Right? Oh my goodness. Chiefs. Okay, I gotta go to bed. But chef, oh my gosh. Okay. All right. All right. We'll have to do this tomorrow. Thank you guys. God bless. Prayers. I'll see you tomorrow. Be good. Be kind. And don't be a jerk. All right. Love you. Bye bye. I've got to figure out how to shut this down. There we go. Jane, stop this crazy thing.